But in fact, my lord, this 31st December, there are other messages which show that they were planning a 31st December get together with friends for a long time earlier. And my lord, the places were being suggested by all people. We'll go to this place, that place, not that she was forcibly taken as the mother tried to complain. Now, Lord Ladyship sees 30th December.
28th.
30. My lord. Page 5.
Yes.
Which number? Third set. My lady has been on?
Yes.
My lord, Ladyship sees on 30th December. What is forwarded by the boy to the girl is Telangana Excise Department giving permission. But Excise Department, your ladyship knows, but the permission is if they want to have a small private party if they are consuming liquor. Now, then please see next page.
Yes.
No, I'm sorry, same page below, 3rd January. Your ladyship sees there are missed calls. When she calls, not picked up. We don't know what transpired, what was the fight or whatever. Next page, regular, some forwards of messages on 5th January. Left side, my lord, something that the girl sends, the photographs. Next page, again, 5th January, my lord, photographs of something else. At the bottom of the page, my lord, again, typically, my lord, in a friendship, because the mother calls it a relationship and I don't know them as well, but I'm only, even if I take the allegation to be true. But please see page 9. I think the problem starts, my lord, after the missed calls start happening from here. 7th January, the mother admits relationship broke off. But 31st December, 1st January, the nature of allegations made, which, my lord, in the original complaint were at the nature of sexual harassment, lord, nothing of that nature reflected from, lord, the contemporaneous surrounding circumstances. And this is a test your ladyship, my lord, has laid down in the SC/ST case, that even if the complaint were to make, in this case, had the original complaint made an allegation about penetrative sexual assault, which is section, my lord, 5 and 6. Even then, if there is something for the court to see that this may be something that is just added for the purpose of spicing up the complaint, the court can look behind. Luckily for me, but I have a much lesser burden to discharge because if I take the allegation entirely, post proper legal advice, post them contemplating legal action from March, filing the complaint in the month of May, 8th May, if they have not made that, that in my respectful submission singularly entitles me to the grant of a limited benefit of doubt for the purpose of anticipatory bail. Your ladyships are not deciding the issue, your ladyships are not discarding the improvement, your ladyships are not saying that no case is made out. As long as the court thinks that this is a matter where if I need to be taken into custody, that is the original sections required me to take into custody, it's a different issue. They did not require me to take into custody. So any improvement made, as I said, my lord, the normal latitude may not be available in this case because the original complaint is filed, as I use the expression, my lord, with full contemplation, full deliberation, full legal advice, my lord, and your ladyship may see the language, my lord. It would have done me proud. Honestly, my lord, I'm not trying to demean it. It's a very well drafted legal complaint which clearly emanates, my lord, from some very good legal advice they have taken. So if someone who's so legally well advised uses, my lord, the nature of language which I'm complimenting them, that is not making this allegation, any allegation made thereafter may be incorrect. My lord, lastly, my lord, very quickly now I have to show some law and then I'll conclude, my lord. My lord, your ladyship may kindly have, my lord, POCSO Act. My lord, the object of this act itself.
Yes.
My lord, this was pursuant to the Convention on the Rights of Child. My lord, the last para of that act, and whereas the state parties to the Convention on the Rights of the Child are required to undertake all appropriate national, bilateral and multilateral measures to prevent, my lord, A, the inducement or coercion of a child to engage in any, my lord, please mark this, unlawful sexual activity. My lord, original object was not any sexual activity, unlawful sexual activity. the exploitative use of children in prostitution or other unlawful sexual practices, the exploitative use of children in pornographic performances and materials. My lord, then the definitions, my lord, I'll skip. My lord, what may be relevant though for your ladyship to note would be 2A, which is aggravated penetrative sexual assault. D becomes relevant, my lord, because under the Indian context now, we have defined the word child to be any person below the age of 18 years. Now, this has but however come up, my lord, for judicial consideration. My lord, then your ladyship may see the original sections were 11 and 12. Your ladyship may kindly go to section 8. 7 is, my lord, sexual assault. 8 is punishment for sexual assault, 3 years and extends to 5 years.
Yes.
11, my lord, is sexual harassment. 12 is punishment for sexual harassment, which may extend to 3 years and shall be liable to fine. The improvement, my lord, they tried to bring it is under 5, which is aggravated penetrative sexual assault.
Yes.
But I have not been privy to what they are saying. So in the original complaint, not even in relation to the 4 incidents, single incident alleged of penetrative sexual assault. Now for it to come under an aggravated penetrative sexual assault, while I am still in the blind about how they try to attract this section, my lord, it will require something more egregious. My lord, it may be under, my lord, KLMN, I don't know. My lord, the learned public prosecutor will tell your lordships how, my lord, that improvement brought it under this. My lord, K is whoever taking advantage of child's mental or physical disability commits, my lord, penetrative sexual assault, may not apply in my case, my lord, in my assessment. 11, whoever commits penetrative sexual assault on the child more than once or repeatedly. But as I said, as I see the complaint, there is not even once. So now 6 is the punishment, which extends to 20 years or remainder of natural life. My lord, after this act, my lord, was made, your ladyship says this was in 2012. My lord, there was, my lord, Justice Verma Commission that was constituted, which dealt with this. My lord, I am showing these two very quickly, my lord, before I go to the judgments, my lord, that I want to rely upon. My lord, Justice Verma Committee in 2013, my lord, said that they recommended, my lord, that this must be brought down to the age of 16 on the supposition that after the children cross the age of 16, they will have slightly greater maturity. And my lord, therefore, this POCSO offences, my lord, must be brought to, instead of 18, that must be brought down to 16. But I must fairly state, as I stated in the beginning as a senior counsel, I must bring it to your ladyship's notice that this has not been accepted. My lord, the Law Commission also recommends that this has to be brought down to the age of 16. My lord, what I will now place for your ladyship's kind consideration is, even with the act being what it is, just give me that Verma Commission. Which crop note is it?
No, but it has not been accepted. So
not been accepted. So, my lord, I'm not there. But with the act being what it is, my lord, the matters have come up for consideration before the court. But I am placing 2 or 3 judgments for your ladyship's consideration, and that will conclude my arguments. My lord. First, my lord, that the my lord, High Court. Please can you give me this judgment? Bombay High Court. Vijay Chand. Lord, there are many judgments, but I just want to trouble your ladyship with only 2 today.
you have filed copies here along with
But
this
I am just giving this.
compilation,
No,
or-
my lord, no, my lord. That was only on the aspect of your ladyship's power, the court's power to grant. Lord, this is the Bombay High Court judgment. And your ladyship sees, my lord, provisions of POCSO Act, my lord, were also coming up for consideration. Para 2, 363, 376, Section 4, Section 8 of POCSO. My lord, then from Para 8 onwards, 7 onwards, I'm sorry.
Yes.
Insofar as the offences punishable under 4, 6 and 8 of POCSO Act are concerned, it may be stated that the provisions of this law, though stringent in nature, would not deter the court to grant or refuse bail in order to secure the ends of justice. the conduct of the prosecution in this case is indicative of the fact that she left, there should be prosecutrix, that she left her home without informing her parents by her own will, and also stayed with the applicant for 4 days. No doubt that the prosecutrix under the purview of POCSO is a minor. However, the facts of the present case indicate that she had sufficient knowledge and capacity to know the full import of her actions and what she was doing, and had only thereafter voluntarily joined and stayed with the applicant for 4 days. Attention is drawn to the decision of Justice Ms. Mrudula Bhatkar in the case of Sunil Mahadev Patil to contend that the consensus of the prosecutrix who is below the age of 18 years is a mitigating circumstance for trial court to consider it. In furtherance to the above, the court has laid down certain specific guidelines after taking into consideration relevant case and also the ethos and development of the age of the young offenders in the Indian society in general. Court in para 8, 9, 11 and 12 has laid down certain principles. Not the quoted portion start at the foot of the page. Next page, my lord. Second line.
Yes.
If a girl is a minor between the age group of 15 to 18 years, and if it can be safely inferred that her consent was obvious, then it is a mitigating circumstance. Some trial courts dealing with such bail applications, especially after Nirbhaya, started taking a strict approach, and the accused are denied the bail only on the ground that the prosecutrix being minor below 18 years, her consent is immaterial. Therefore, the case of rape on such minor, no bail can be granted. This is a matter of concern. In view of the increasing offences against the women, especially of rape, the legislature both found it obligatory to deal with those offences with severe punishment, and women can be protected if the laws are made rigorous. Therefore, the report of Justice Verma committee was accepted, and necessary and significant amendments were made in these two sections. A wrongdoer is to be punished, guilty is to be convicted. However, this is important, at the stage of bail, the court has to consider prima facie under what circumstances the offence is committed by the accused. In the criminal law, the court cannot ignore the intention or motive behind the act, and that is an important factor in the commission of offence, so also to decide the quantum of sentence at the end of trial. So in the case of bail. Today, teenagers are exposed to more sex-related issues, and lot of material is also available to them to know the sexual relationship between a man and a woman. Because of their impressionable age, girls and boys both may tend to get provoked, and there may be a curious and very compelling demand of the body to get into such kind of relationship. Sexual urge differs from person to person, and there cannot be any mathematical formula in relation to sexual behavioral pattern of teenagers, as biologically whenever the child turns into puberty, the child starts understanding his or her sexual needs. The nature of response depends on the upbringing, peer pressure, how civilized the environment is. Sex requires proper physical and emotional preparation, as it results in many physical and emotional consequences. This is all considered as sexual maturation. Therefore, some sets with view to regularize sexual behavior of the community have acknowledged this biological factor, and therefore the early age marriages are performed in some religions or communities. Taking into consideration the social and biological factors, the lawmaker have considered the age of 15 as an age of consent when marriage is performed. Taking into consideration this background, the trial judge has to pass an order of bail in such cases. The overall circumstances while dealing such applications can be summarized thus. When a boy and a minor girl are in love with each other and chose to live together without the consent of their parents, then the following factors are to be considered. 1. What is the age of the prosecutrix who is minor? Not a difference between a 14-year-old, 13-year-old versus a 16, 17-year-old. Whether the act is violent or not. 3rd, whether there are antecedents or not. 4, whether the offender is capable of repeating act or not. 5, whether there is likelihood of threats or intimidation if at all the boy is released. 6, whether any chance of tampering with the material witnesses when their statements are recorded. It is also to be taken into account in such cases that a boy in his early 20s deserves to get employment and to plan, stabilize and secure his future. So proceeds on the predication that the boy may not be minor. He may be little above 20. Then 9. Insofar as the present case is concerned, it is seen that the victim has left her parents' house without informing the parents, stayed with the applicant for 3 days and 3 nights, and also she confessed she was in love with the applicant and travelled along with him to different places. 10 is the last para. It is settled law that a court, while deciding a bail application, has to keep in mind the principal rule of bail, which is to ascertain whether the accused is likely to appear before the court for trial. There are other broad parameters also, like gravity of offence, likelihood of accused repeating the offence while on bail, whether he would influence the witnesses and tamper with the evidence. These are the regular parameters. but I am only trying to, my lord, bring it to my lady's kind notice, but that some of the most stellar judgments, my lord, in fact, have been rendered by ladyships, my lord, of different high courts. This, my lord, quoted part is also, my lord, by one of, my lord, the ladyships who adorns the high court bench. My lord, the next judgment that I am placing for your ladyship's kind consideration is Delhi High Court, which is Ajay Kumar's case, only for the limited purpose of, my lord, bail. Lord, para 4, in my opinion, the intention of POCSO was to protect children below the age of 18 years from sexual exploitation. It was never meant to criminalize consensual romantic relationships between young adults. However, this has to be seen from facts and circumstances of each case. There might be cases where survivor of sexual offense may be under pressure or trauma be forced to settle. Then para 5 refers to a Madras High Court judgment. 6 is, my lord, the Dharmender Singh judgment, which I am reserving, where, my lord, the High Court, several other High Courts have taken presumption at this place cannot be placed, my lord, until charges are framed. Then 10. Thus, this is not a case where the girl was coerced into a relationship with the boy. In fact, Miss So-and-so herself went to the applicant's house and asked him to marry her. The statement of the victim makes it clear that this is a romantic relationship between the two and the sexual act involved between them was consensual. There was in fact no dispute also. In my case, my lord, this needs to be, because the lordship saw there is absolutely nothing in the complaint. My lord, then if I may read further, although the victim is minor and hence her consent does not have any legal bearing, I am of the opinion that the factum of a consensual relationship born out of love should be consideration while granting bail. To ignore the statement of the victim and let the accused suffer behind jail in the present case would otherwise amount to perversity. 11. I am cognizant of the fact that the proceedings before me, this is what I wanted to place, is for grant of bail, not of quashing of FIR. It is not a case where the slate of the applicant is wiped clear. In the circumstance of the present case, the applicant is entitled to bail for the reasons enumerated below. Then last judgment that I want to place for your ladyship's kind consideration is, my lord, of the Andhra High Court,